Mama's in the living room watching Judge Judy. I'm in the kitchen eating leftover sushi, and she yells, "Oh, girl, you gotta hear this one." A man was arrested for running a theme park, and when they said, "Where's your license?" he said, "My dog get it." Oh, you can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout, "Girl, you gotta hear this one." Mama loves to laugh at how absurd life is, says it's all a comedy and I'm her audience. And I love the way she makes fun of the world. She said, "You'll never guess who's with their girlfriend. It was a man who didn't get us out of the bed. He said, I've been through hell and now I need some help. You just can't make this shit up. You just can't make this shit up." Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout, "Girl, you gotta hear this one."
Hey everybody, it's Squid. Welcome back to the channel for part 2 of the shit show that is the Day Hatch getting away. And the little is in her part of her Halloween costume. So excuse her missing half her face. Also, just a thing of somebody does not like to Mr. Squid is in bed. So I have the door closed and she's running back and forth between my bedroom and here, causing some chaos. So if you see her running and hit me, and you see me have to engage mama mode, it's because somebody is acting like a 3-year-old who didn't take a nap. And you know what? We're just going to do that. And I know there's a lot of freaking people alive right now, so we are going to make this as quick as possible. If you are here, if you are on replay crew, please hit that like button. Please subscribe, and please subscribe to my new channel as well. I am working on getting all the stuff I need to start recording videos over there. Right now, kind of got an awkward setup, so I have some things on order, which is really hoping I get that channel up, going, and hopefully monetized sometime next year, so that all the stuff that I'm buying can be paid for. And Ongong Hero, thanks for getting us started with 10 gifted Squid Pro Quo memberships. I appreciate you guys. And I know there's not going to be many people here because other people are live and somebody is live talking about a very popular case. So I know how that's going to go. Drama over this drama. However, this, I feel like people need to hear about. This pissed me off on so many levels that it's not even funny. This is the Maya Kowalski case. We started talking about it earlier today. We will link part 1 in the description of the video. I just set this up on a whim because I had to go with a quickness. So we had to do some painting because somebody decided to paint some of my walls blue with some dry erase marker. So we had to do some painting, and we had to do it before Mr. Squid got home, because I'm just saying there are some things that are better off where we use the phrase, "Let's not tell your father." And this would be one of them. Yeah. Anyway, getting back into where we left off, we're on page 15. We're going to try to go through this as crazy as possible, as quick as possible. Thank you for the $20 super chat. Dumpster Jesus is weeping. Yeah. And so far in part one, TLDR for part one, what they were talking about was the recap of the case. So if you have been living under a rock for the past 5 years and you have not heard of this case, see part one for the judge's description of the situation, which I took exception to now thinking about it and having the good part about doing these in separate parts is I get to think more about what we read earlier. And the judge, although having to be official, like the way he's writing this is just pissing me off. The way he's writing this is, I've never had chronic pain. I don't know what it's like to have chronic pain. I don't believe a word this fucking bitch is saying. This is what I imagine that he's thinking while he's writing this. Not calling Maya the B word, but just saying. And this just pisses me off because as a chronic pain patient, as someone who has been gaslit by the same industry that I worked in and went to college for, have a degree in, and worked in, I was gaslit by my coworkers, my bosses, my doctors, everybody I knew thought I was, oh, well, you look healthy. Yeah, well, I can't feel my legs. So I might look like I'm fine, but I can't feel my feet. Like when you're in the neurologist's office and he says, "Hey, I have 2 med students here today. Would you mind if I brought them into my office so that they can see your reflexes? Because it's not very often they're going to see reflexes like these." Okay. Yes. I think we need more money for this. Oh, yes. And because of the nature of what we are talking about, these streams, I'm going to do my best to hold my tongue. But in the first stream, we had a swear jar going for super chats because we get demonetized. Also, I bought a teleprompter so that I can make videos and actually look at the screen or look at the camera and read my script and things I've wrote and written and all that. Live streams, it's not such a big deal because I'm looking at different computer screens, but recording a video, it's really awkward to be like looking over here and looking over here. Like I said, I'm hoping to get that other channel monetized and make some more long form video content with this stream or with this channel so that I can start to increase my revenue, my AdSense revenue, and pay for the stuff I bought because I'm going into debt and Mr. Squid is going to look at me like I'm fucking nuts. Oh, yes. I forgot about the John Drops kids. Yes. Hong Kong here earlier, we were starting to think about the Dumpster Jesus, the John Shop kids. My first ever meme was made during this. It was marked, and Megan showed it on her stream, and I was slightly proud. Marked safe from being dropped by Johns Hopkins today. Like, we're good. But as a therapy assistant, as an occupational therapy practitioner, as they call it these days, this just pissed me off. Like the therapist just pissed me off. So we're going to get started on page 16. Oh, I already ordered it. I ordered I'm going to end up getting a bigger desk because not all this stuff is fitting. However, I do too. Those are the good old days. Like, hey, Timothy, thanks for the $2. I will start the swear jar. Technically, Unhung Hero got us started up here, but I appreciate the input. It is very much appreciated, and I just let you guys know that no super chat goes unappreciated. I don't want for you guys to ever think that I expect or that I'm ungrateful. Every super chat, even the 99-cent super stickers, are like, y'all are paying to hear what I have to say. It's like, well, things I never thought would happen for $1,000, please, Alex. All right. But as a therapy practitioner, this just made me angry. Listening to not only the nursing staff, which I've had some shitty nursing staffs. Like, you get nurses that are just salty. Like they've dealt with lots of patients that are bullshitting them and all that, and you get hardened people. Just like in any situation, you get nursing staffs and therapy staffs that are just sick of the bullshit. However, there's limits to it. You can think whatever you want when you get back to that nurse's station. However, when you are in front of that patient, when you are with that patient, you need to have some sort of fucking integrity. So, like, mm, mm, no. No, 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 no. That would never even cross my mind. At that point, it was like MySpace was the thing. So, like, YouTube was, I mean, even if it did exist back then, it was not like this. My swear jar would have been filled in the first hour of work. Yeah, it's a thing. All right, let's get back into this, and I will try to keep my swearing to a minimum. But you will see my medical and my ethical side come out. Yeah, fucking agreed. If they can't have the integrity, then they don't need to be in practice. And you get jaded. Like I am used to people cussing me out. I am used to being told no. I'm used to people being told that they don't need me, blah blah blah, and whatever. That's part of the reason why this stuff, like the person who called me fat in the comments yesterday, I just laugh at, because it's like, okay, if you think you can do better, you do it. But it's just having the insight in this case as not only a chronic pain patient, but I also know how a fucking hospital system works. I worked in a 700-bed hospital with a 45-ish bed inpatient rehab unit, and I switched back and forth. I started like a float, like 2 days on rehab, 1 day on acute care. I'd float to acute care, and then switched to a neuro floor, switched to a cardiac floor for a couple of years, which I floated to cardiac surge and ICUs, and the floors above us were orthopedics and oncology. So I've seen a little bit of everything. And although I did work with adults and not children, I did have to I have education in pediatrics. Everybody has an education. That was not my focus. It was not where my career was. But like, I look at it this way. This is not meant to put children down or adults with cognitive disabilities. However, adults with cognitive impairments, especially post-stroke and dementia, resort back to being children. So you have to kind of know how to work with children, because it's kind of like they're one and the same. The older you get, you start to revert back to the ways you were younger, cognitive wise, body function wise. It's why you get incontinent, just like you were when you were little, because you can't feel those signals. Things start to go back to the way they were. It's one thing to be jaded. It's another to look for abuse everywhere and have a position to make lives miserable with it on a whim. Yeah, I could do a whole stream, and I might do a whole stream where I just bitch about this, so we can make it through this. That might be next Monday or next Tuesday. But I might have a whole stream where I just do nothing but tell my stories and why this like what is supposed to happen. Scheduling. I heard them talk about scheduling. I can explain how therapy scheduling, at least in my hospital, worked. And I can't imagine it being much different for other hospitals. So yeah, cool. I always wanted to be a kid again. I mean, there's a reason why 3-year-olds and teenagers are around the 13-year-olds, and 3 are about the same, like, impulse level. Well, the older you get, when you get at least dementia, you start to revert back to people who speak dual languages. They say English is their second language and they had a stroke. They will resort back to what they've known the longest. They will resort back to their first language. I had a patient that was from Italy. They spoke fluent English before their stroke. After their stroke, they only spoke Italian. Yeah, come to think of it, Grandpa was writing on walls. Oh, if y'all want to see, it was I put pictures in the Discord of what the walls look like. I had to paint, and we have two different colors of paint and the three different colors of paint, but one is black, so I can definitely tell the difference with that one because we have an accent wall in our bedroom that's black, and I accidentally painted the first wall in the living room by the TV the wrong color. So I had to paint it twice. Um, so there's that. Yep, they resort back, dealt with it being family members, caretakers, nursing assistant, care coordinator. Yeah, it's an interesting experience to say the least. All right. We kind of left off in the middle of a sentence here. So we're gonna kind of go to the top of the page. As the shelter placement, JHatch was required to implement the dependency on court orders. Those orders required JHatch to comply with visitation guidelines, blah, blah, blah. And I'm going to paraphrase this because this is 47 pages. So we're going to hit the highlights on each page. Moreover, the order directed that the court would not micromanage or countermand JHatch's policies, and that the absent clear and compelling reasons JHatch staff was to be free and address the medical needs of their patients without the courts, the parents, or others interfering with professional judgment. Well, your professional judgment is fucked. You have no professional judgment. That being said, doesn't this sound to everybody else like, no offense, Uncle Buck, but pass the buck? We're going to put it, JHatch says they have to comply with court orders. The court says their orders give leniency to JHatch to implement their policies, and it just sounds like nobody's taking fucking responsibility, and that is half the problem. Just yeah. Baby Squid was trying to be she was trying to be an artist and turn our house into a Smurf. She was also trying to turn herself into a Smurf. Mr. Squid gave her a bath tonight and saw the remnants on her belly. However, I did not tell him I had to paint the walls. Shh. Keep that secret, please. Yeah, but this just sounds like it's passing the buck and no one's taking responsibility because the court's saying one thing and JHatch blaming the court and the court blaming JHatch. Seems to be typical of the world these days. JHatch was required to take part in the sheltering of Maya by virtue of the shelter order on October 14th. The department sought to have Maya sheltered based on ongoing CA and imminent danger. Yes, the imminent danger of her mother being so desperate to do whatever she can to take her child's pain away. Yes, that's the desperate. Yeah, and they get immunity. I hate immunity. No one should be immune for shit. You act like an asshole, you break policy, you treat people with disrespect, expect to be fucking disrespected back. You break laws, expect to be prosecuted. I don't care if you're the janitor or you're the president of the damn hospital. I feel the same way about hospital immunity as I do about judicial immunity. Fuck it. Immunity just gives people free license to be assholes. Oh, here comes Mr. Squid to close the door because I'm being too loud. The department placed Maya at JHatch for ongoing medical treatment, including psychological evaluation and weaning off ketamine. So they didn't believe that she was on ketamine to begin with, and then they want to wean her off. Like, to make it make sense. Within the text of Chapter 39, the legislature established in its intent expressly, the purpose of this chapter are to provide for the care, safety, and protection of children, and to prevent the occurrence of CA neglect and abandonment. Yeah, but to a hammer, everything looks like a nail. And that's my phrase, and I'm sticking to it. The legislature further stated its intent that Chapter 39 be liberally interpreted and construed in conformity with its declared purposes. Courts may not extend, modify, or limit the statute's express terms or its reasonable or obvious implications, because to do so would be an abrogation of legislative power. And then the footnote was the dependency court orders included directives on screening visitors through the department and who specifically would be permitted visitation. Moreover, all parts of a statute must be read together in order to achieve a consistent whole. Effect must be given to every clause of the statute, meaning given to all of its parts. Here, the trial court erred by not considering the entirety of Section 39.203(1)A and its application to the facts of this case beyond J. Hatch's immunity from claims premised on or immediately resulting from the reports of suspected CA. And nothing in the record suggests that J. Hatch's participation in implementing the dependency court orders, as it was required to do, was not done in good faith. Enter Sally Smith. Nothing that bitch ever does is in good faith. Also, telling a 10-year-old that her mother is in psychiatric care, that should immediately take away any immunity. Catherine Beatty, I said this in the last stream, I'm going to say it again. You should be on a list somewhere, far, far away from ever getting anywhere near another child. If you have family members with kids, they shouldn't even be allowed in the same room as you. You are one evil, evil slut. Oh, wait, never mind. To be a slut, you have to have somebody willing to fuck you. Although the process was unfortunately slow and painful for the Dohertys, nothing reveals that the investigation was not instituted and conducted in good faith after a legitimate report of that. As such, the department as an institution participating in good faith in acts authorized or required by that statute was immune from civil liability which might otherwise result by reason of its action. Okay, you take away the immunity for the reporting of the abuse. You committed fraud. You billed for something that you told the patient and the patient's family that she did not have. Yet you billed for it. That's fraud. You should be investigated by CMS. CMS should come in and look at every claim that you've ever filed in the last decade and pull your certifications. If you are accredited by anybody, they should come in there and yank your certifications. Joint Commission. Need we go there? I have so much hatred towards this fucking hospital. Damn easy there, sunshine. Told ya. I have personal hatred because this is I have personal hatred because this is my career. And I take it personally when people who are in medicine act like ass fucks. Because this is my reputation. Because if they look bad, we all look bad. And like hell am I letting someone like that bitch make me look bad. Oh, I'm calm. Just welcome to me expressing my professional opinion when I don't like somebody. The state argues correctly that Pope could have and should have done more, but the legislature did not condition immunity on doing more than seeking medical assistance in good faith. And I think this case needs to go to the Florida legislature. This case needs to be a why we should get rid of immunity case. The legislature could have imposed more conditions. The statutory scheme at issue is intended to protect those who might be overzealous in protecting children from potential abuse. Discussing Section 425, a predecessor to Section 39. This is not to suggest that 39(1)A provides absolute immunity. Well, it fucking sounds like it does. It provides immunity from liability that might otherwise result from good faith reporting or good faith participation in acts authorized or required by Chapter 39. Section 827 of Florida statutes protects against liability for carrying out the protective measures of Chapter 827 on behalf of the protected class. It does not protect against failing to carry out the protective measures. There are complexities created by the interplay of Chapter 39 with the claims raised in this case. We are aided in interpreting and applying Chapter 39 by the amicus briefs filed by the American Academy of Pediatrics. Fuck them. Remember, the American Academy of Pediatrics is also the ones who wanted to give the COVID vaccine to 6-month-olds. So the American Association for Pediatric or American Academy of Pediatrics can suck a dick. The Children's Hospital Association and the Florida Hospital Association. The Florida Hospital Association articulated its concerns with the trial court's ruling in this case. Can you guys now see why I never want to work in big healthcare again? Because I have massive problems going all the way down to the American Academy of Pediatrics. I am trying to talk to a former coworker of mine because he is retired now, but he is a Tai Chi instructor. He would do continuing ed classes and in-services with us about doing Tai Chi with patients. Yeah, those professional medical associations get huge money from pharmaceutical companies, which is why I don't trust anybody. From being on the inside for so many years, I don't trust anybody. And even on my other channel, I take that as an educational only and as when I release videos, trust but verify. Never be afraid to verify what I am saying. I will post resources of all the studies that I used to make my videos in the descriptions because transparency is key because these fuckers aren't transparent. And I'm sorry I'm not showing you guys this, but it's one of them situations where I'm faster when I was not showing it because I don't know, for some reason when it's up here it's distracting to me. But there's so much the words that I can't say on YouTube in this that it's not that I'm scared to show it. It's one of those situations where I feel like I should show pages and move on because of the situation of like YouTube is starting to throttle my videos. I'm not a big creator by any means. However, I am learning that there is a difference between how YouTube treats your videos when you've had like 400 of them and when you have over like 2,000, 3,000 subscribers, and it does when you're like 1,000, 1,500. So I'm having to be with some of these just a little bit more leery than I normally am, especially since I am dropping a lot of F-bombs. A lot of my streams lately have been limited ad revenue. Let me just put it that way. You get a nice little yellow sign. And Jeff, I appreciate you as always, but you know what I mean. Like I am not a small creator in the fact that I realize that having 4,200 subscribers is massive and takes a lot of work, and a lot of people never make it there. So I am grateful, but I am also aware that I'm not 25,000, 50,000, 100,000 type of creator right now. So like but I do notice a difference when I hit 4,000 that YouTube treated my videos differently. And it got a lot more picky about what I say, if that makes sense. Whereas like 1,000, 2,000, none of my streams really got hit with ad revenue or limited ad revenue. These now are. torts for this case are adding up: fraudulent billing or upcoding, negligent misrepresentation, medical malpractice, unjust enrichment. Ooh, that's a good one. Healthcare fraud under the Federal False Claims Act. And see, because I'm not a pediatric practitioner, I don't know how billing works and how insurance works with pediatric care. So, but I do know that everything I did, I had to account for. And I would get audited occasionally. And if my notes didn't match what I billed for, somebody's in trouble. So it's kind of a, you have to take I can't imagine it being much different for pediatrics. I just don't know exactly because it's not the person's insurance, it's their parents. And I also don't know how Medicaid works with children. It's from a therapist perspective. The trial court found as a matter of law, J. Hatch had reasonable basis for suspecting that their patient was the subject of that word, that J. Hatch acted in good faith by reporting that suspicion, and that J. Hatch could not be held liable for any cause of action directly arising from sheltering the child pursuant to a court order. And this also goes into how corrupt family court is. So, and remember, family court judges and prosecutors, we hate them because they all on the same damn team. They're all actors of the state. Whether they try to show as much discretion and fairness as possible, they still all get paid by the same person. Unfortunately, these findings were rendered meaningless at the trial itself when the court permitted the Kowalskis to attack see the way this is the way this is written. Attack J. Hatch's basis for suspecting abuse, its motives for reporting that suspicion, and present evidence to the jury of the psychological impact of the court-ordered sheltering period. Well, guess what? This is where anybody in Florida needs to write your damn state congressman and tell them that they need to take this case up in the legislature and figure out this fucking immunity statute and take it away. Because, when I start doing my magic mic dance, I chant, okay, chanting. For those of you on replay crew who might not have caught the first one, I was joking because somebody called me fat in my comment section yesterday, and I told that person that if you don't look like either, because I don't know if it's a girl or a guy, because all they showed in their profile pic was feet, and they have no content. So unless you look like Sydney Sweeney or Channing Tatum, kindly shut the fuck up. It makes no difference whether peds or geriatric for any of those torts. It's just one of those, I don't know, as far as like, because I was never, billing was never my thing. Coding and billing is not my thing. So I would just put in my codes, but we did learn a lot about insurance in college. That was fun. So different, because in inpatient, it's different. Inpatient rehab is different than long-term care and subacute rehab. And it's just, it's fucking crazy. I may be fat, but you're retarded. Yeah. I use the phrase of, I might be able to lose weight, but your personality dysfunction is permanent. The actions of J. Hatch with respect to their good faith, mandatory reporting were repeatedly called into question and leveraged by the Kowalskis in their effort to secure a finding of civil liability and award for damages. Yeah, because their good faith, they proved over and over and over and over again that these people did not act in good faith. And with them not acting in good faith, wouldn't the liability go away? See, and that's where I would push back on this appeal. And I would try to take it to the Florida Supreme Court, because with respect to their good faith, that is what is as far as I'm aware, by Chapter 39, it is the good faith You acted in good faith. That protects your immunity. They did not act in good faith. The Kowalskis proved over and over and over and over again that they did not act in good faith. And I hate, you will be able to tell when I act in good faith because I'm like this. It's when people are happy-go-lucky with their shitty actions that they didn't act in good faith. If they feel bad, they're like, oh my God, this is a big deal. But if they're just fucking happy to pick up a phone call and make a phone call for no reason, yeah, there was no good faith whatsoever. They didn't like that Beata knew what was best for her daughter. And you see it every day with adults. You see it every day when an adult goes to a doctor and feels gaslit by their doctor because their doctor gets pissed that the patient comes in and is like, I think I have this. I think I have this. I think I have this. I've had it before. Like, I went to my doctor one time and I was like, I have a sinus infection. I know it's a sinus infection because I've had these ever since I was 12. I've had one sinus infection a year since I was 12. Welcome to my world. Like, and the doctor's like, I don't think it's a sinus infection. Gave me just a cold pack, basically. Welcome to the military. And guess what? That's so bad. Guess what? Severe sinus infection. It's almost like I fucking told you what to look for because I know my body. I've been living in it all my damn life. So you see it with adults all the time, but adults can make decisions for themselves. With kids, when you try to, it's a fine line of, it's this fine line of advocating for your children and advocating for your family, but also not. I think it was a cultural thing too, because I'm not Polish, but I grew up in Wisconsin. Lots of Polish people there. Polish people are just straightforward. There is no they're like Russian light. They're like, there is no give a shit. There is no sugarcoating shit. It is what it is. And sometimes there is a big difference between like a Polish person and like an English person. Like here, a lot of English descent because it was an original 13 colony. Cultural difference between Wisconsin, where people tell you to go fuck yourself every 5 seconds, and down here where people are like trying to be super polite. And it's like my mom goes to work and they tell her, you're being rude, because my mom asked what to someone. She didn't hear a question. She turned around and went, what can I do for you? And the person bitched and reported her that she was being disrespectful and rude. It's like, no, bitch, I asked you what the fuck you wanted. And I did it without cursing at you. You better be blinking your lucky damn stars. Yeah, down here they say bless your heart. Up north they just tell you to go fuck yourself. Yeah, same with us blunt Germans too. Yeah, Wisconsin is very German, Polish, and Irish heavy. But mostly German descent. And the fish fries and just a lot of German stuff in the beer. But down here, it's like every state in the US is like a different damn country. For those of you who don't live here. The trial court found that Section 39.203 immunity flows for any civil liability that may result by reason of the report, and that without question, an investigation, shelter, removal of custody, and prohibiting visitation are all outcomes that could logically could occur from a report to the hotline. Trial court implicitly recognized that dependency courts, that is, those sheltering a child and restricting or prohibiting visitation, may result from the reporting and investigation of that naughty word. Yet the trial court failed to give effect to its interpretation by permitting the jury to hear significant and inflammatory testimony concerning the restrictions put in place by the dependency court and the impacts of those restrictions on the Kowalskis. Well, that proves that they didn't act in good faith. And I think that was Judge Carroll's point, is it allows the family to prove that they didn't act in good faith, which gets rid of your immunity if you did not act in good faith. That's why I do not like this judge. Not what he's saying, but how he's writing this. You can just tell from the very beginning that he was just not on the Kowalski side. Like, you could just tell. Like, just the way this is written, it's like, Hey, JKD Buck, when I was little, I lived off of Fields Erdel Road, if you know where that is. I can't spell it, but I can say it. For example, Mr. Kowalski testified that Mrs. Kowalski lost consciousness and fell to the floor upon learning that she was not going to be able to see Maya, and that during the time that she was unable to see Maya, Mrs. Kowalski deteriorated. She was losing hope. That's not inflammatory. That's the fucking truth. And if the truth happens to be inflammatory, then that's a J-Hatch problem. Like, that's not a Maya and Beata and Jack Kowalski problem. That is, if the truth that she was losing hope happens to be inflammatory and make you look bad, that's a you problem. I don't know what you want me to do about that one, J-Hatch. I'm not on your side. J-Hatch, I believe, should be shut down. Especially since their joint commission shit where they lied. He repeatedly testified to the profound impacts of the dependency court orders on Mrs. Kowalski. Maya also testified to the impacts of the dependency court orders on her, as she should. Like, that's not inflammatory, that's the truth. And from anger and not being able to speak with or see her mother to feelings of isolation. Maya testified that she was suspicious about the comments made to her and the restrictions placed on her. No one ever directly told her what was going on. And as the patient, even as a child, the patient should always know what the hell is going on. If the patient doesn't know what the hell is going on, you as providers suck. I mean, to be blunt, if you don't tell your patient what is going on, you are a horrible provider. Whether it's social work, whether it's therapy, whether it's nursing staff or a doctor. If you don't tell your parent or your patient what is going on, why you were there, and what the treatment plan is, you suck. It doesn't matter if your patient is 3 or 95. You suck. Pick a different fucking career, because this shit's not for you. She testified that and she had to figure out for herself that she was being stripped from her family. She testified that J-Hatch provided her with a My Care journal, and in that she listed names of J-Hatch doctors and nurses with notations and drawings. I was trying to get out of the hospital, and I'm 10. So I'm thinking if they think like I do, then you'll get out. Footnote, whether the trial court's interpretation is correct in this respect has not been raised by the parties to this appeal. We note, however, that the plain language of the statute provides immunity from civil liability resulting from good faith abuse reports. They proved over and over and over and over and over again that this was not in good faith. And I think that's what the appeals court is missing. The good faith. They keep saying it, but just because you repeat it doesn't make it true. Whether civil liability results from, or as the trial court found, flows from the reports or from other acts authorized or required by Chapter 39 is not a distinction we must draw in this case, because J-Hatch was required to comply with dependency court orders as a matter of its good faith participation in the Chapter 39 proceedings, regardless of whether its compliance with court orders flowed from the abuse reports. The trial court erred by not giving effect to that portion of the statute to which it assigned meaning, and it further erred by not giving meaning to all the words within the statute. And you erred by being a complete and total fuckstick. This judge can sit on it and rotate. Courts must give significance and effect to every word and phrase in a statute. That statute provides immunity from civil liability, which might otherwise result of both reporting in good faith. See, the good faith. They proved over and over and over again that none of this was done in good faith. By threatening the patient, if you threaten a patient, nothing you do is in good faith. You threatened the patient. You threatened a patient. Because you know what? When Maya testified to the fact that she was threatened, no one ever, if I'm remembering correctly, no one ever disputed her claim. No one ever said that they didn't say that to her. True, but they still, if I remember the trial correctly, they still in the ER were kind of basically saying, we don't believe a word you're saying. So if you, I've worked in hospital, fucking hate ER staff. I hate ERs. In this case, you really don't want to know. My channel would be yeeted if I gave my blunt, truthful, and honest, non-filtered opinion on these fucksticks. Because working in a hospital for so long and making many trips to the ER my damn self, I know how it is. Like, I'm sure if I would have been underage with the stuff that I was going to the ER and reporting, I'm sure if I would have been underage, my mom would have been, they would have thought my mom was abusing me because I was, can't do this, can't feel this hurt. I'm not going to tell you everything, but like, I'm sure that like my mom can agree. She's in the chat somewhere. That if she would have been the one to take me to the ER, a lot of the times, yeah, it would have been, we could have ended up in some of the same situation. So, it's just, and she was not in the second, if I'm remembering also correctly, the second time the call was made, she was not in the ER because those were 2 days apart, and you don't get bedded in the ER. So those were at least 12 hours apart, and you do not stay in the ER that long. They either admit you for observation or they discharge your ass. You don't stick around in the ER for that long because they need to get you. The ER is to get you either taken care of, get your life saved, and then get you to the part of the hospital that you need to go to. So if I'm remembering the dates from the part 1 earlier, it's not, those calls were made. Ma'am. Yeah. Sorry, we've got company. Are you in a better mood now? Thank you, bud. There you go. And hey, Island, how are you? Sorry, Island. I'm in a zone in a mood. I wanted to finish this in one session in one sitting, but we didn't exactly get to because somebody decided that they wanted to color my walls like a Smurf. Who decided to color on their face? I said yeah. Yep, yours a triage, not a room block. And we got to a point where we had to no one could stay in the ER. No one could be turned away from the ER. So usually hospitals would say, hey, our ER is full, to an ambulance, and they'd go to the next hospital. We were not allowed to divert ambulances anymore according to Milwaukee County law. According to Milwaukee law, we were no longer allowed to divert. So we would have to get patients out earlier, so that we'd have to get patients out of the hospital earlier so people can get from the ER can get into beds. The artist formerly known as Baby Squid. Get that out of your mouth. Hi. I don't think anything, even in the ER, was done in good faith. Participating in good faith in any act required by Chapter 39. Please stop kicking my desk. 91 of Maya's 97 days in J-Hatch were the result of dependency court orders wherein the department had been given placement and care responsibility of Maya while she remained under protective supervision. Uh-oh. You want my water? Yeah. Okay. Yeah. Yeah, cutest, but this was so this was earlier's artwork. If I let's see. This was just one of many that I had to clean up. This was the other one. So we had a little yeah. We had a little, that's why we didn't finish this issue. But I also didn't want to make this a multi-day stream thing because she didn't do it if there's no video proof. Yeah, my house is haunted, so there's that. I didn't want to make this a multi-day occasion for the simple fact that this pissed me off when I saw it yesterday. It kind of like, it didn't ruin the day, but like I just wanted to give Maya a giant long distance hug. Yeah, today's prior stream was preempted. Yeah, we got a so oh, the closing arguments were also inflammatory. Counsel for the Kowalskis argued that J Hatch took Mrs. Kowalski out of the game. They did. By changing its diagnosis. They did. And treating the Kowalskis like criminals. They did. Counsel then went through J Hatch's defenses because if we get rid of the defenses, then that's all that is left is the Kowalskis case. Counsel for the Kowalskis argued that something happened between Mrs. Kowalski and J Hatch that ticked J Hatch off. Yeah, she was telling them how to treat her daughter. That pisses people off. When you go in and you tell someone how to do their job, they get pissed. Whether you are actually doing it to protect your family or you are doing it to be an asshole, doesn't matter. It still generally pisses people off. Causing J Hatch to call the department and that J Hatch was not going to let this brusque lady with an Eastern European accent come in and tell them how to do their job, which I think that they were racist. Just my personal opinion. And I don't throw that word around lightly. But they used the fact that she was Polish against her. They argued that J Hatch calling the department hotline was retaliatory against Mrs. Kowalski and that she self-deleted because she knew that if she did not take drastic action, Maya would end up in some kind of foster care or die. I mean, here's the thing. That whole thing, this judge is annoying me, but like that whole paragraph, he basically proved our point in the sense of when she unalived herself, a week later, her child was home. That kind of like, kind of puts the whole, I don't know. The trial court's errors in interpreting and applying section 39-.203 immunity should result in a new trial for all claims. See, and I don't think it's all claims either. It should be for the claims that they get immunity for. You don't get immunity from fucking billing claims. Like, if you fraud the government out of claims and you fraud insurance companies out of claims, there's no immunity for that. So the fraudulent billing claim, this is where it would be like, you're saying that they should get immunity for that? Huh? That makes no sense. We agree that the trial court's ruling on section 39.203 immunity premeditated the entire trial. A new trial is required on all counts, not otherwise disposed of by this opinion. False imprisonment, Trial court denied J. Hatch's motion for a directed verdict as to the false imprisonment claim for J. Hatch's actions between October 7th and October 13th. This was error. Ugh. It sucks. The essential elements of a cause of action for false imprisonment include unlawful detention and deprivation of liberty of a person against that person's will. She wasn't allowed to leave without legal authority or color of authority, and which unreasonable or unwarranted under the circumstances. Footnote 13, we note that J. Hatch has not argued that evidence of good faith participation in actions authorized or required by Chapter 39 is not admissible because such actions cannot form the basis for liability. The FHA, however, contends that if a party is immune from any civil liability that might otherwise result in any reason of certain conduct, then evidence of such conduct should not be offered as part of an effort to support a finding of any form of civil liability. And my thing is they settled with Sally Smith. So if they had immunity and she had immunity, why did she settle? Yeah, but this judge even says that in earlier pages that the hospital said they were following the court order, and the court order said that they were following the hospital's policies. So no one took responsibility for anything, and they were passing the buck. No offense, JKD Buck. So this whole thing is bullshit. And also, I have a huge problem with being a former hospital employee. I have a big problem with anybody having liability or immunity for anything. Stand on ground. If you don't think you did anything wrong, defend yourself. You don't get immunity. Fuck immunity. Like, you don't need to be immune to anything. How about you just don't fuck up and there won't be a problem? So, and that offering such evidence creates an obvious and significant danger of unfair prejudice, confusions of issues, and misleading the jury. So this whole thing is prejudiced by the fact that I hate immunity. So every time I hear the word immunity, I'm going to get pissed at it, and I'm going to tell this judge how much I think he fucking sucks, and the state of Florida how much they fucking suck. And I'm going to tell each member of the Florida legislature that they're ballless and spineless and a bunch of pussies for not taking this into consideration and getting rid of liability. So I'm a little fired up. Although J. Hatch sought summary judgment for this false imprisonment claim as well as the other false imprisonment claims on the basis of 39, J. Hatch does not challenge the court's denial of the motion for summary judgment. The only challenge it raises on appeals is to October 18th through the 20th and January 6th false imprisonment claims concerns punitive damages because they just didn't want to pay. They just don't want to pay. All of this is because they just are bitching. They're hiding behind shit instead of that is true. To a point. But when I believe a claim is retaliatory in nature, there's also the person making the claim should not be the one that had words with the mother. Because that tells me right there that that's retaliatory. That person who had words with the mother should tell somebody else, hey, can you go look at this without telling them the situation? Hey, can you go talk to your charge nurse? Hey, you need to go see this person and evaluate them and see what you think. And then come back to me and I'll tell you what I saw and we'll compare notes. That is what I would do. Especially since you're in the hospital and they're not doing anything to that patient right then and there. So that's what I've done when I've seen shit. I've gone to my OT or the PT seeing them, and they'll be like, when you go in and see this patient, come talk to me afterwards and we'll have a discussion. I didn't just instantly jump to conclusions. based on, especially if I had an issue with the patient or the patient had an attitude with me, because no, like there are ways to handle it that do not look like you just retaliated against someone. And I don't know if these bitches were stupid, new, inexperienced, or had never done this shit before. But you know how many times I had to go and report shit? But I also made sure that I had a second opinion on my opinion before I reported shit. Because I didn't want to be wrong and risk ruining somebody's life for no reason at all. October 7th to the 13th, allegations stem from J. Hatch's refusal to release Maya from the ER in PICU. J. Hatch argues both that it had legal authority and that there was no evidence that keeping Maya in its care was unreasonable and unwarranted under the circumstances, whether because of Maya's pain levels and overall health at the time or because of the suspected child abuse. We need only consider whether the hospital was without legal authority or color of authority, a question of law, to resolve this issue. Whether the Florida Public Service Commission has the authority to act is question of law, which is subject to de novo review. J. Hatch's legal authority or color of authority stems from 39-3.395. Any person in charge of a hospital or similar institution or any physician or licensed healthcare professional treating a child may detain that child without consent of the parents, caregiver, or legal custodian, whether or not additional medical treatment is required. I have such a problem with this verbiage, such a problem, especially now that I'm a parent. Like when this case happened, I wasn't, like, back in 2018, obviously I was not a parent. But when this trial happened, baby Squid was very, very, very young. Baby Squid was a baby. She wasn't walking yet. Like, I was still nursing, which is why I got to watch Megan's coverage at night, because I was awake. However, that being said, I have a very big problem with the way this is written, especially as a parent. This right here, whether or not, especially with situations like CHOA, Children's Hospital of Atlanta, there's been some issues with Children's Hospital of Wisconsin. If the circumstances are such, or if the condition of the child is such that returning the child to the care or custody of the parents, caregiver, or legal custodian presents an imminent danger to the child's life, physical or mental health. But I have a problem with this, considering you have states like Arizona that have multiple calls on one kid. CPS shows up constantly. Before they show up again before the last report is done. And yet, no evidence, nothing happens, and that child ends up dead. So, I have a very, very big problem. We are also mindful that Section 39.395 also requires that any such person detaining a child shall immediately notify the department, and the department shall immediately begin a child protective investigation in accordance with the provisions of this chapter. Beyond the initial detention and reporting, the department legislature has placed no burden on the person detaining the child, instead has placed a burden on the department. There's the second problem. If the department determines, according to the criteria set forth in this chapter, that the child should be detained longer than 24 hours, it shall petition the court through the family attorney representing the Department of Children and Families as quick as possible, and not to exceed 24 hours, for an order authorizing such custody in the same manner as if the child were placed in a shelter. Yeah, and that's the problem too, is like, I can't imagine. I just, like, I literally had to sit down with my pediatrician and I talked to her about this case because of the fact that I have chronic issues. The chances of her developing chronic issues are quite high. So I was like, hey, by the way, this is my medical history. I was gaslit for years. If I come to you with a concern about my child, it's a true concern about my child, and I don't want to end up in a situation like that. I almost filed a complaint against the hospital that I had to take her to when she was 6 months old when she got COVID, because the ER doctor was giving me an attitude about the fact that her dad had COVID and didn't have the vaccine. And she started basically berating me. The nurses didn't care. They were like, I wouldn't have fucking got that thing if I didn't lose my job. However, the ER doctor, I was damn near ready to file a formal complaint with the hospital because I was sick of this bitch. She's lucky that we were lucky that we weren't in a bar parking lot somewhere. Let's put it that way. I was ready to catch a charge for that. If I wasn't holding my child and listening to my child scream and it break my heart, yeah, because my child is sick with a fever. My child has COVID at 6 months old, and your concern is that her dad doesn't have the vaccine, and that's why she got sick. Oh, people suck. So I almost filed a complaint against an ER doctor here because of that. So I have absolutely no problem with telling doctors to go fuck themselves. Having done it while I was working in a tactful way, and having been my grandmother's power of attorney for 9 months in the hospital that I worked at, and being on the first name basis with the surgeon, I was able to tactfully tell quite a few doctors as my grandmother's power of attorney to go fuck themselves, and that they ever talked to me or my grandmother like that again. I would talk to the hospital administrator, who just happened to be on my Facebook, by the way. Just a, All right. Oh, when you're good at, not to say that I was the best at my job, but when you're good at your job and you respect people, people tend to respect you back. And a couple of those people were very high up doctors in my hospital, who wrote me personal thank you letters for what I did for them. So I have them in my little goodie bag of stuff that patients and other people wrote me over the years. And I actually went through it. That's why it's on my brain, because I went through it last weekend. As such, JHatch is immune from liability resulting from its detention of Maya between October 7th and 13th. Intentional infliction of emotional distress, Maya Kowalski. 2 claims specific to Beata were resolved by the jury in favor of the Kowalskis after the trial court denied JHatch's motion for directed verdicts. JHatch contends that its motion for directed verdicts should have been granted because the Kowalskis failed to present evidence of conduct directed at Mrs. Kowalski, and the Kowalskis' evidence was insufficient as a matter of law. We agree. Oh, I fucking hate this court. JHatch's issue concerning the corresponding motion for directed verdict on punitive damage is therefore rendered moot. To support the claim for intentional infliction of emotional distress, a plaintiff must prove the wrongdoer's conduct was intentional or reckless. The conduct was outrageous. I'm pretty fucking sure this was outrageous conduct, because this shit would not have gone down in my hospital. I can tell you. Like, my hospital was not the absolute greatest hospital, but I can tell you, from being on the very unhappy patient family side and the caregiver side, this shit would not happen in my hospital. That shit would be shut down in my hospital. Every patient or every nurse, social worker, like if freaking Kathy Beatty was a social worker in my hospital, that bitch would have been fired. I'm telling you, that bitch would have been fired. Like, my mom knows where I used to work. They don't play. They would look for ways to fire people that acted shady. The conduct caused emotional distress, and emotional distress was severe. Well, she felt the need to unalive herself, so that sounds pretty damn severe to me. But, I know I'm biased, but I don't give a shit at this fucking point. The trial court must make the initial determination on a motion for directed verdict that evidence presented meets that high standard. Pleading a cause of action for intentional infliction of emotional distress is one thing. Avoiding summary judgment or prevailing at trial is quite another. And because of the outrageousness test is objective, testimony as the plaintiff's belief on whether the defendant intended to cause emotional distress is of no moment. That's what's hard. It's objective, and you can't tell another person what they're feeling. You could never tell another person what they're feeling. So to base a claim based on how someone feels when that can change minute to minute is difficult. Testimony as to the plaintiff's belief on whether the defendant intended to cause emotional stress is of no moment. We therefore decline to address J. Hatch's argument that Florida does not recognize, I'm not even self-deletion. Response of the person who is the target of the actor's conduct does not control the question of whether the tort of intentional infliction of emotional distress occurred. Relevant to the estate's IID claims, in order to state a claim for emotional distress based on one's own emotional distress, a plaintiff must be present when the alleged extreme and outrageous conduct is directed towards a third party. Appellants were not present when the alleged mistreatment of their daughter took place and may not claim emotional distress for her injurious or offensive treatment. I could see that if it was like your cousin, your sister, your mom, and you're all adults. But like the law treats a child, and this is bad to say, but it's true, as property. It's different with a child, someone who is not legally responsible for themselves. I have a big problem with the way this is, like, with this, because, like, I'm sorry, if my child's bullied at school, that's still going to make me upset even though I wasn't present for it. Different but same, if you get where I'm going with it. Like, you don't have to be present when your child is injured or offensive treatment took place for it to cause severe emotional distress to a parent. A parent-child relationship is different than a sister-sister, is different than even maybe now my mom and I, because I'm 40. Like, I'm able to handle myself, where a 10-year-old is not able to handle herself or should not have to handle herself in a room full of adults. Otherwise, the conduct alleged to be outrageous must be directed at the plaintiff. Appellant's claim for intentional infliction of emotional distress fails because here there was no showing of outrageous conduct directed at appellant herself. In all cases, we have found in Florida, recognizing the tort of intentional infliction of emotional distress, the plaintiff was the receipt of the insult or abuse, or the message clearly directed at plaintiff through a third person. Stated differently, if the plaintiff is not present to witness the outrageous conduct, the plaintiff must have been the target of the outrageous conduct. And I think Beata was the target. Like, which part? The child-parent relationship? A child shouldn't have to take care of themselves in a room full of adults. That is why a parent exists. That's why we don't let little people do their own thing at age 10, 11, 12, 13. That the brain doesn't fully develop until 25. So I'm still going to be offended for my child if something happens to her. I'm offended for my child based on what a fucking lawyer said. So, like, and that was directed at me, not her, and I'm still offended for her. And very few times will you ever see me offended for somebody else, but my child cannot speak for herself. So I mean, she's working on it, but she's 3, so y'all give her some time. Uh, the Kowalskis presented no evidence that Mrs. Kowalski was the target of any of the conduct alleged to be outrageous. Rather, the heart of the Kowalskis' claim, repeated in various ways throughout multiple bench conferences and asserted before the jury, was that the separation of mother and child with knowledge by both and without the ability to combat it was outrageous. The fact that the appellate judge does not find that outrageous, we have a people problem. And I hate people because people act like this. Because people, the law or not, and I'm all for, generally speaking, things being justified by the law and playing devil's advocate. However, this is a child. And when you are talking about a child who lost her mother, and you are talking about a child like her mother's not supposed to give a shit or not supposed to be offended for her, my mom still gets offended for me, even when I'm like, leave it the fuck alone. Like, I'm like, it doesn't fucking matter. And my mom is like, well, yeah, the fuck it does. Sorry, I lost my charger. I just dropped it. I wear this thing, but it's getting to the point where it's starting to hurt today. So I can't have anything on my wrist because my wrist hurts right now. Like touching my wrist. Like I was going to keep my hair down, and it got to the point where my hair on my neck was starting to hurt my neck. Once again, if it sounds weird, it is. But, you know, that's the shit that like can't have anything on my wrist. Like even this, sometimes I'm like, it hurts. The Kowalskis argued a plan that is told to the mother that we're going to take away your child and there's nothing you can do about it. The real outrageousness is the systematic nature of the actions against Mrs. Kowalski through this, and every contact that she had, everything she learned reinforced that there was a plan to take her daughter away, and that is outrageous in our society. It is. The Kowalskis contended that there was concerted efforts to raise the pressure on Mrs. Kowalski. If this doesn't get her, let's suggest that Mrs. Kowalski get a divorce. And the fact that Beatty even brought up the fact that Jack should divorce Beata, inappropriate. Fucking inappropriate. I cannot stress. Like, I would never in my career have I thought about asking a patient's family member if they were going to get a divorce. What? What? Like, ethical nightmare. Once again, that bitch should be on a list somewhere. And if this doesn't get her, let's tell Maya that I'm going to be her mother. Creepy, inappropriate, unethical. The Kowalskis acknowledged that these statements were not made directly to Mrs. Kowalski because she wasn't allowed in the hospital, but were funneled to her through a proxy, which was her child or her husband. That Mr. Kowalski or Maya relayed what they had seen or experienced is not evidence that J. Hatch's actions were directed to Mrs. Kowalski. And there was no evidence that Mrs. Kowalski was somehow the target of the statements made to either Maya or Mr. Kowalski. By telling a child that you want to be her new mother, that's not implying that you want to take away her mother from her. Oh, fucking this trial court, man. I feel bad. Like, I'm gonna pray for this judge's family because they have to put up with him. I'm done praying for people. I'm gonna start praying for their families who have to deal with them. And hey, Dan, how are you? It's absolutely fucking ridiculous. Ugh. Moreover, the trial court recognized that the allegations in the operative complaint were insufficient when it granted J. Hatch's pretrial motion to dismiss the intentional infliction of emotional distress claim as to Mr. Kowalski, with the exception of the actions immune under Section 39 and the assertions that Mrs. Kowalski suffered from Munchausen syndrome by proxy, which they never actually, if I'm remembering the billing correctly, and this one, yeah, and a child shouldn't tell her parents, as someone said. Yeah, the first time that I ever hear that someone says something to my child and they use the phrase, "do not tell your parents," is when I'm going to need to grift for bail money. Just saying. Just saying. Because, yeah, I have a big ethics issue. Like, regardless of this and the legal aspect of it, I have a big, I repeat it, but it's so true. As someone who worked in a healthcare setting for 10 years, well, 7 years, if you include school and the last year of school being clinicals and stuff. 7 years. The ethics issues that I have with these people on so many levels are like, why the fuck would you do that? J. Hatch has a problem with, they have a culture problem. The people they hire, I don't know if you got them from the same place where Lynette gets fucking lawyers, but like, does Florida have like a secret underground for shitty human beings and they all collect in one area? It's oh yeah, I'm back. Had to paint the walls. If you back up the stream a little, about maybe in 40 minutes, 30 minutes, I showed pictures of the walls. And that was after I wiped on the windowsills, because the windowsills clean really easy because they're plastic, or vinyl or whatever the fuck they're made of. But wood and marker do not get along. Just saying. So we had to immediately but I wanted to finish this today because I really, really didn't want to drag this out for multiple days, because you can see my attitude. My attitude is very shitty. I have a huge problem with this case from a parent, from a healthcare provider, from a caregiver, because even though my dad and my grandpa were alive at the time, my dad's still alive, my grandfather is not. I was my grandmother's power of attorney, literally at the same time. Like August 2016 to April 2017. So, Florida's sort of the appendix of the USA. It's not really needed, but it's there anyway. No one really knows why it's there. There is little difference between the allegations the trial court found legally insufficient as to Mr. Kowalski's claim and the evidence presented as to the estate's claims. Kowalski's evidence was legally insufficient. The directed verdict should have been granted. Maya's emotional distress. In denying J. Hatch's motion for directed verdict specific to Maya, the trial court considered evidence for what J. Hatch should have been immune from liability and evidence of other pleaded torts. This was error. And I thought Judge Carroll did a really good job at balancing all the bullshit. But, and sometimes it doesn't get infected. Oh my goodness. We reiterate the actions for what J. Hatch should have been immune pursuant to 39 can't not be used to establish liability. The department placed Maya with J. Hatch. J. Hatch's participation in the Chapter 39 proceedings, as well as its initial reports of suspected CA to the department, pervaded the Kowalski's evidence of intentional infliction of emotional distress against Maya. The trial court was required to consider which of J. Hatch's actions should have been immune from liability and which actions should could support the independently pleaded tort of emotional distress, medical professionals' disagreements about a complex medical case, and perhaps overzealous implementation of dependency court orders. The very, very politically correct way of saying that. Are not acts that are intolerable in a civilized community. The rendering of substandard medical care does not constitute the intentional infliction of emotional distress. So I know this is, they're quoting case law, but are you basically admitting that you wouldn't, JHatch sucks? My thing is if you can look at this case and you can see this and you can be like, yeah, I would definitely send my kid to JHatch. Okay, then maybe they're not guilty. But if you look at this case and you are like most people and you're like, I'm never getting near JHatch's parking lot. I'm not even driving near JHatch's parking lot in case I get into an accident and have to go there. These people are nuts. The ethics of this fucking hospital, like, I would never, ever send my kid to JHatch. Ever. I would rather drive to freaking, like, Texas and go there. Hell, I would drive thousands and thousands of miles in order to not have to go to JHatch. Good faith actions to protect children are neither utterly intolerable in a civilized community, nor beyond all possible bounds of decency. Indeed, Section 39 immunity protects those who might be overzealous in protecting children from potential abuse. Stop being overzealous. Do your job, but don't try to be a super fucking hero, because nobody likes a superhero. Nobody likes when someone tries to do their job better, bigger, harder than everybody else. Just show up, do your job to the best of your ability, and go home. Don't try to be a super fucking hero, because that's when you fuck up. To the extent that JHatch took actions within its legal rights under Chapter 39 or otherwise, it cannot be liable for emotional distress. A privilege exists as a matter of law to engage in reckless or even outrageous conduct if there is sufficient evidence that shows the defendant did no more than assert legal rights in a legally permissible way. Additionally, emotional distress conduct might be volitive of any other recognized tort. That is, facts upon which it is based must be independent of any other alleged tort, because the actions of the chargeable defendants here cannot be deemed to fit within the false imprisonment category. Those actions will not support a claim of intentional infliction. Obviously, if the sole basis of the complaint for emotional distress is a privileged defamatory statement, then no separate cause of action exists. A plaintiff cannot transform a defamation action into a claim for emotional distress simply by characterizing the alleged defamatory statements as outrageous. Where the conduct alleged to be outrageous itself is a pleaded tort, claims of emotional distress cannot lie. Here, the Kowalskis relied upon evidence of other pleaded torts to establish the emotional distress claim. The law is clear, however, that the evidence supporting Maya's 3 false imprisonment claims, as well as her battery claim and medical negligence claim, cannot also be used to meet the legal threshold for her emotional distress claim. Medical negligence. Oh, here we fucking go. Here we go. My brain's going to melt. JHatch contends that the trial court erred in its denying its motion for directed verdict on the narrow issue of apparent agency as it relates to Dr. Smith, and that Chapter 39 otherwise immunizes Dr. Smith's actions, such that JHatch cannot be held liable for those actions. We agree. Well, Lottie fucking da. An apparent agency exists only if all 3 of the following elements are present: a representation by the purported principal, a reliance on the representation by a third party, and a change in position by the third party in reliance on the representation. Mr. Kowalski testified that he was unaware Dr. Smith was not a JHatch doctor at the time he first met her. but could not specify the date. He testified that she was wearing a white lab coat when she came into Maya's room and started asking questions. Maya testified that she was unaware of who Dr. Smith was or in what capacity she questioned Maya's father. An email dated October 12th from Mrs. Kowalski's email address was entered into evidence. In the email, Mrs. Kowalski reported that on October 11th, she and Dr. Sally Smith, who was sent by the department to investigate the possible child neglect, had a second visit to which Ms. Kowalski described as Maya's illness and the doctors involved in Maya's care. Oh, footnote. Further evidence supporting the negligent hiring and supervision claim cannot be used. The claim was resolved in favor of J. Hatch, and while the Kowalskis argued that the evidence taken as a whole indicates that there was a desire and plan on the part of Ms. Beatty to separate Maya from Mrs. Kowalski, and that there was a plan by the hospital to force Beata and Maya and Jack to change their story. To the extent that such evidence is not subject to Section 39 immunity, there is no evidence of such concerted effort. Okay. Concluding that plaintiff's testimony as to her beliefs on whether defendant intended to hurt her was of no moment. The subjective response of the person who is the target of the actor's conduct is not to control the question of whether the tort of emotional distress occurred. Moreover, the trial court granted summary judgment in favor of J. Hatch on the Kowalski's conspiracy claim pre-trial. Oh. The one doctor I had didn't even introduce himself, and my doctor made him come back in and apologize. We had this, I will never forget, well, I say I'll never forget it. We had an acronym that we were supposed to announce, introduce, explain, thank, and something else. And I was in with my grandmother one time, and I was working. I was on my lunch hour, so I had my name tag. But this doctor walks in, starts talking to her. The nurse is in there, the CNA is in there, respiratory therapy is in there, and I'm in there. And we're all looking at each other. My grandmother would look to me like I'm supposed to know who every fucking person in this hospital is. There's 700 beds in this hospital. I have absolutely no fucking clue who this dude is. And she looks at me, and I literally look at this doctor. I think he was a nephrologist. Not really sure. But I look at him, and I was like, we have this policy here at the company I worked for. And I was like, and this patient would really, really appreciate it if you would use it. And he looks at me like he's about to like yell at me. He's about to go to my freaking supervisor. And he's like, oh, and you're working with her? And I said, no, I'm her granddaughter and her activated power of attorney. How can I help you? 2 years. I saw that doctor at least once a week, would not make eye contact with me in the hallway. But I said hi to him every fucking time I saw him because I am that petty. Yeah, that's me. Don't fuck with my family, whether it be my grandmother or my kid. You know? Oh, yeah. It was the CNA laughed because I knew the CNA. The CNA was a friend of mine. The nurse, I had worked on that floor previously. I was not assigned to that floor, but like I was on the floor below it. So when I needed to pick up a quick acute care patient to make productivity, that would be the first place I'd look. So the nurses up there kind of knew who I was. And I know, right? Like I said, I had to deal with fighter pilots for fucking 5 years. I am not afraid of a fucking doctor. Like, that's why I'm not afraid of anybody. Like, I'm not afraid to talk to anybody. I don't get intimidated by people because I dealt with fighter pilots and fucking doctors. Like, come at me, bro. The two professions with the biggest fucking egos on the fucking planet. Doctors, fighter pilots. My two careers. Just saying. I can deal with them fucking egos. YouTube ain't shit. But that's also why I learned to just, like, keep people at arm's length, and if you start getting dramatic, I don't talk to you because people ain't worth my fucking time. Ugh. Thus, no later than October 11th, Ms. Kowalski was aware that Dr. Smith was acting in her capacity as a CPT physician, and certainly by October 14th, sheltering hearing, Ms. Kowalski was also aware. The Kowalski presented no evidence that they materially changed their position prior to October 11th or the 14th, based on Dr. Smith being a parent agent of JHatch. Rather than the Kowalskis acknowledge that they were unaware that the JHatch had given Dr. Smith full access to Maya's medical records. At the time, such access was provided. Oh, and the accessing of the medical records when you're not that was another sticking point I have with this trial. This is another well, think about it. There's with all the people that covered this trial and that talked about it and did hearings and stuff, that I'm covering this document by myself. It's why I released a short yesterday about it. It's why I posted the first page to say that I had it, and why I'm doing a stream today. Because I've been fucked over by people wanting to collaborate with people and waiting, and then having them talk about it on their channels without me. And it's like, nope, I just do my own shit. That's why I don't stream with anybody except for Spawn, who was honest, actually streaming at the same time as me today. You know, oops. I just have a big problem. The other sticking point was the medical records and accessing the medical records when you're not actually on a treatment team. When you have not been added to the treatment team, even as a CPT physician, my thought process and my ethics is you need to be added to the treatment team in order to have legal access to legal access to the medical record. Like, I couldn't go in and look at my own medical record, even though I had been a patient in that hospital system, because it's unethical. So to go into, like, I could only go into people's medical records who I was assigned to, or if I was given the task of doing documentation reviews. So if I had to go in, like, I was on a documentation committee. So if I was given a list of 6 therapists and I needed to go in and pick out documentation to review their documentation, I'd have to do a case review and I'd have to do a medical records review of that patient, even though that patient wasn't mine. But that was a legal and necessary reason for me to go in and do it. I don't know how I feel about this. When you have privileges at that hospital, but you don't actually work for that hospital. There's an ethical issue that I don't know. I just can't quite get over. And I could be completely baseless in that, and other people could have no problem. But to me, that's another ethical sticking point with Sally Smith. The apparent agency theory should have been rejected as a matter of law by the trial court, and directed verdict as to that specific claim should have been granted. Nonetheless, even where Dr. Smith fucking grammar. Ugh. Grammar. Yeah. Definitely big no-no and unethical to access electronic medical records without legal permission and not on care team of patient. Yeah. The only time that was appropriate for me was I was doing documentation review of the treating therapist. But I had documentation in front of me that said, like, what I was doing, and I had to sign my name doing a chart audit. So there's a difference. Like, I was in a work capacity. I just don't know how I feel about this, because especially when you're not an employee of that hospital. Yeah, I don't also like want my like when I like I said, this would never happen at my hospital because we had a policy that it was called AIDED. It was called announce, introduce, explain to the patient why you're there, discuss with the patient what you're doing, and thank the patient for their time. That was your, you know, that was your acronym for not fucking up a patient. And you always announced that you were there. You introduced yourself. You introduced yourself and you explained to them while you were there. You didn't play this fucking game of not wearing a name tag or having your lab coat cover your name tag. I don't personally remember exactly how that was described, but you know, if you have it on your shirt and you cover it with your, you know, your coat so they can't see it, that's a pretty shady thing. But also me being from that background, my ass would have been like, and you are who? Who are you? Why are you here? What do you need? Like, I'm trying to take care of my daughter. You're obviously someone in a white coat, doctor, could be a therapist. I don't know. Who the hell are you? So, you know, I you know, like I just oh fucking I have so many problems with her, but I have problems with this hospital system and their policies as a whole based on this shit would never happen based on the policies that my hospital had. It would never happen. See, generally, nonetheless, even were Dr. Smith an apparent agent of the hospital, because Dr. Smith was a CPT medical director, she was authorized by Chapter 39 to take the action she took. Oh, once again, Florida. Her actions would not subject J. Hatch to liability unless J. Hatch was not participating in good faith acts as authorized by Chapter 39, which I don't believe anything that J. Hatch did was in good faith, based on the testimony that I heard. It was the Kowalski's burden to prove that either that J. Hatch was not participating in good faith in an authorized or required acts, or that Dr. Smith was not acting in her capacity as the CPT medical director. In admitting evidence of Dr. Smith's actions without proper consideration of statutory immunity, the trial court relieved the Kowalskis of their burden. Oh, punitive damages. Here we go. J. Hatch contends the trial court erred in denying its motion for directed verdict on the issue of punitive damages to false imprisonment and battery. In all civil actions, plaintiff must establish an award of punitive damages. That Florida statute, a defendant may be held liable for punitive damages only if the trier of fact, based on clear and convincing evidence, finds that the defendant was personally guilty of intentional misconduct or gross negligence. Clear and convincing evidence and intermediate burden of proof. Remember, this was a jury. Like, this was not just the judge deciding this. This was a jury. It's like you, and I hate the fact that the judge here doesn't seem to give a flying fuck that this was a jury verdict. Requires an intermediate burden of proof. Requires the evidence must be found to be credible. The facts to which the witnesses testify must be distinctly remembered. The testimony must be precise and explicit, and the witnesses must be lacking in confusion as to the facts in the issue. The evidence must be of such weight that it produces in the mind of the trier of fact a firm belief or conviction without hesitancy as the truth of the allegations sought to be established. And 18, although a reversal of the judgment as to the October 7th through 13th false imprisonment claim moots the issues specific to that claim, we would have otherwise concluded that a directed verdict was warranted as to punitive damages because J. Hatch's actions during that period do not meet the definition of intentional misconduct or gross negligence. I really hope that if this judge has kids, that his kids are required to go to J. Hatch for their entire childhood. I'm a vindictive bitch, and if you're going to say that this hospital is immune, you send your kids there. Send your kids there, specifically to the heart unit. I heard they provide excellent care there. In the case of an employer, principal, corporation, or other legal entity, punitive damages may be imposed for the conduct of an employee or agent only if the conduct of the employer or agent constitutes intentional misconduct or gross negligence, and the employer, principal, corporation, or other legal entity actively and knowingly participated in such conduct. The officers, directors, or managers of the employer's, principal, corporation, or other legal entity knowingly condoned, ratified, or consented to such conduct. I don't know, taking pictures of a child in her sports bra? I'm just saying. Just saying. Sounds like some shady shit. Or the employer, principal, corporation, or other legal entity engaged in conduct that constituted gross negligence, I don't know, by telling a child she's faking it. I just, I'm, sounds like this judge retried it in his head. A jury deciding was not in good faith. That was yeah. Not to derail you, but it's been quiet there for a bit. Did she decide to sleep or is it too quiet again? She's with her dad. So she's probably asleep. Which means I get to sleep in her room tonight. Which means I get a whole bed to myself. So I don't complain when she sleeps in our room. I get to go to her room and sleep by myself. It's a win-win. Intentional misconduct is defined as defendant having actual knowledge of the wrongfulness of the conduct and a high probability that injury or damage to the claimant would result. I don't know, like telling her that she has to shit herself because you won't take her to the commode because you think she can walk. Like even, yeah, it's 3, but still, it's one judge who wrote the decision. So it's for the purposes of our conversation, it's 1. Because not all 3 judges wrote the decision. This is his writing and his writing style and his wording. It might be the judges as a whole's decision, but it's not even the reasoning, it's the wording and the case law that he decided to put in. It's how he wrote the sentences. I think the way he wrote this is very shitty. In the sense of the way he wrote this says I already had some shit in my head before I even heard this case. The way he wrote the sentence structure, like I don't like this judge. And I didn't like this judge during the appeal either. If I remember which judge this was, there was one judge that I was like, he's a fucking asshole. I can't stand him. I don't even like the look on his face just says he had that RBF. I'm like, I have RBF, but like he has RBF. So Island, I get what you're saying. It's a 3-judge panel, but for the talking about the way this is written, it's only written by 1 judge. So I think it's Judge Black. But because not all 3 judges sat down and wrote this together. It's one judge. And because of that, I get to criticize the 1 judge. And I will continue to criticize the 1 judge. And J Hatch, because J Hatch can fuck themselves with a sandpaper condom. As to the January 6th battery and false imprisonment, Miss Beatty testified that she was told to take photographs of Maya before Maya could leave the hospital for the dependency court hearing. The Kowalskis presented evidence that a risk management analyst within the risk management department of J Hatch directed the actions on January 6th. Evidence established that it was J Hatch's policy that the risk management department reports to the senior counsel and then senior counsel reports to the president of J Hatch. I have a really big problem with risk management and pictures. The way that it was presented, I have a really big problem with from an ethical standpoint and someone who's worked with patients. I didn't work with kids, but I still worked with patients. And I worked with patients that were in handcuffs and things like that, among other things. Risk management does not have actual contact with the patient. Risk management does not have, it's hard to describe, but like risk management part of the treatment team. And it's it risk management can just, if they tell me to take pictures, I'm going to say no, unless it comes from a treating doctor. And secondly, the social worker should never have patient contact, as far as like hands-on patient. So the fact that, like, I don't know any social worker that has ever been in the room when a patient's changed, unless they knocked on the door in the middle of something, which happens. People, you're trying to do ADLs with a patient, and shit happens. People knock on damn doors all the time. But I know a lot of social workers. I don't know any social worker that has ever been present while a patient changed. That would be something that would be a nursing assistant responsibility from a doctor's order and in the chart, not an email from risk management to a social worker. That right there seems like shady policy. Like, and I'm going through this as not only hating J Hatch, but like going through it from someone who worked at a hospital. What policies? There's a policy problem here. If this was your policy is awful. Your policy needs to be changed. And you need to stop allowing social workers to see patients in a state of undress. That is not their responsibility. It is not social workers' responsibility in a hospital. That is, if something needs to be done with a patient in the state of undress, that is a nursing issue. And in order for it to be a nursing issue, that email should have been CC'd to the social worker. But that email should have been CC'd to the social worker. The social worker and the doctor should have spoken. Then an order put in the computer for someone to take pictures. That way it's documented and legal. I don't think any of that was legit. I don't think any of that was on the up and up. Yeah, no social worker I've known or worked with in patient care has ever been in the room while a patient was in the state of undress. I've had social workers come up to me, or not come up to me, literally on our floor, my computer, another computer, or the PT's computer, social work. So literally I was like, 6 feet away from social work. I've had social workers talk to me about, hey, we're looking for this. If you see anything, please, let me know. But I've never had a social work. I worked with adults, and then when they went to court hearings, it wasn't family court. But that being said, there's just an ethical issue with it. Everything in a hospital needs to be documented in the patient's record, including if you take pictures of patients, that goes into a patient's medical record. Those pictures never made it into her medical record, and they were taken with what I believe is someone's personal device, which means that they were never put in the medical record. They were on someone's personal device, which means they went home with someone, which wouldn't that be child porn? Just a side note, if that's on your personal device, wouldn't that be considered child porn? We had a unit camera. Every floor had a camera, which is another reason why I say that she needs to be on a list somewhere. Because if she did that with like, oh yeah, that's no problem, and she didn't question it at all, and there's no evidence that she questioned any of this, that's a problem. That's a problem. We had a unit, like a camera, and if you needed to take pictures of something, like wound care needed to take pictures all the time, they used a hospital camera so that when pictures of a patient were taken, like we even had in rehab, sometimes the patients would give consent to be used in training, like, hey, we're going to be training on this exoskeleton. here's a patient using it. Is it okay if we record you while you use it or take pictures of you while you use it, whatever. You had to get signed patient's consent, and you used a hospital device. You did not use your personal device to record a patient. It's so, oh my God. Use of a personal device to do anything. And if I'm remembering correctly, I could be wrong because the trial was obviously 2 years ago, but I do not remember hearing anything about, I wouldn't remember hearing anything about it being a hospital device. Oh, it's just creepy on so many levels. And like, no. Construction managers, superintendents, and construction workers were not on the record before us. Officers and managers, members of the limited liability companies. There was no clear and convincing evidence that JHAC actively, knowingly participated or engaged in intentional misconduct or gross negligence. That's the thing about actively participating in. You don't have to actively know that you're being negligent to be negligent. Especially in medicine. You can be negligent without realizing it. A managing agent is like an individual, like a president or primary owner, who holds a position within the corporation, which might result in his acts being deemed as acts of the corporation. And that girl took my water. I wouldn't say it's CP by default, but the circumstances sound questionable, definitely worth investigating on the hospital side. And I don't believe that they ever did. I have not found any evidence, any reports. I've searched and I have not, because that was one of my things of like, did they investigate? And I didn't find any evidence that they investigated any of this. But I'm sorry, you take a picture of my child in a state of undress without my consent. Once again, I'm going to be grifting for bail money. Oof. The AI dictation used at clinic even have to have a signed consent form by the patient or parent, legal guardian, or it can't be used for dictation to the EMR. Interesting. We didn't have all that fancy stuff when I worked. Oh my goodness. Let's see. Plaintiff failed to present evidence establishing that defendant employees held positions as corporate policymakers, which might result in conduct deemed to be the defendant corporation's acts. Identifying officer, director, or managing member as the requisite position in order for the action to have been taken by the corporation. Likewise, there was no clear and convincing evidence that the actions in question in this case were relayed to senior counsel or to the CEO, much less that anyone ratified or condoned the actions other than the risk management analysis. Well, why does he have a job? Or she have a job, whatever. Before one may infer that a principal ratified an unauthorized act of his agent, the evidence must demonstrate that the principal was fully informed beyond having simple constructive knowledge and that he approved of the act. And there was no evidence that a risk management analysis satisfies the statutory requirement of officer, director, or manager of employees. Then why? See, and to me, that's a pass the buck, because they go, well, risk management told us to do it. And according to the law, risk management does not satisfy the statutory requirements of officer, director, or manager of employees. It's the passing of the buck yet again. Well, this person told us to do it. And I feel like JHatch knew that. Risk management has no legal authority to do anything. So by them saying that they were directed by that risk management, it makes everybody not liable. Nobody gets held accountable for anything. Passing the buck again. And it just fucking sucks. Fucking sucks. And there was no evidence that risk management analysis or officer, director, manager of employees. Finally, to the extent that the Kowalskis argued ratification after the fact, actions taken after the happening of a tortious act are not admissible on the issue of punitive damages, nor can that subsequent actions form the basis to bring such damage. In the absence of clear and convincing evidence, the issue of punitive damages should not have gone to the jury. There's also evidence that JHATCH's Risk Management Committee does not function in real-time decisions and meets only quarterly. Sorry, the thought I had right now would get my channel yeeted, so. Once again, passing the buck. It's not, this person told me to do it, this person told me to do it, this person, it's never, I fucked up. Which I'm sure would have saved a whole lot of time and trouble for everybody. As to the October 18th through 20th false imprisonment, there was no evidence that physicians involved in moving Maya to the EEG room had actual knowledge of the wrongfulness of the conduct, or that moving Maya into a room with video monitoring was reckless or wanting in care. Further, like the claims for January 6th, and it's not the patients who, it's not the doctors who decide what room a patient goes into, it's nursing staff. Generally, when a patient gets to a floor, it's the charge nurse telling someone what room to go in. So the fact that they moved had to be a nursing decision, not a doctor decision. Unless the doctor specifically wrote an order to video monitor, her changing rooms was a nursing decision. By the way, because generally nursing decisions don't, or change of rooms, like sometimes a patient that has a lot of needs, if they find out that this patient has a lot of needs or hits the call button frequently or whatever, will be moved closer to the nurse's station because it's easier to get to them. So staff decisions or room decisions on a unit fall to the charge nurse and the unit manager. They don't go to the doctors. So it's those 7th floor coven bitches. See? Heidi, thanks for confirming I know what the hell I'm talking about. Further, like the claims for January 6th, false imprisonment, and battery, there was no evidence presented that JHATCH participated in the actions. I'm sorry, when someone's paycheck is signed by JHATCH and they are doing the thing, they represent the company. I'm wondering why that is apparently a separate, like, a thing. And that's what I'm not understanding with this. There was no evidence presented that JHATCH participated in the actions or that the officers, directors, or managers of JHATCH condoned or ratified the conduct. Your people. When I showed up to work with my badge with the name of the company that I worked for, I represented that company. I was responsible for that company. I was the face of that company to that patient. So if I fucked up, it was the company's fault because they hired me. So the fact that there was no evidence that JHATCH participated in the actions or that the officers, directors, or managers of JHATCH condoned or ratified the conduct. The nurses did. The nurses are JHATCH. Yeah, they set the policies. That's true too. But I see your point, and I definitely agree with you because they do. My first point was I'm a representative of that company. I am that company when working with a patient. That company, like, just because I'm not a doctor or I'm not a administration or I'm not the president or the chief medical officer, like, doesn't matter. Chief nursing officer, it does not matter. I am that company. So if I fuck up, that company is liable because they hired me. That's what I'm not understanding, the fucking disconnect here. The admission that Wool has no idea if management at any level was ever notified of the calls and emails destroys any basis to ground for a claim for punitive damage against McLean Food Service. Wool makes no allegation that any managing agent of the employer was unaware of customer complaints regarding the stacking of boxes at a restaurant. I don't, the disconnect, like fraudulent billing. Here we go. Trial court denied J. Hatch's motion for directed verdict. Of course they did. Claim that J. Hatch fraudulently billed the Kowalski's health insurance carrier by using billing codes for CRPS. To survive directed verdict, Mr. Kowalski had to establish that J. had made false statement concerning a material fact in the bills to Mr. Kowalski and his insurance company, that J. Hatch knew the statement was false. J. Hatch intended that Mr. Kowalski or his insurer would rely upon the false statement, and that Mr. Kowalski or his insurer would be injured as a result of the reliance. There are 4 elements of fraudulent misrepresentation. And although judges tend to know the law, judges don't know medicine. And it's why it's why just because you're an expert in one area does not make you intelligent. And it's another reason why I hate when someone is either a doctor, a lawyer, a pilot, or whatever, and they get that attitude of, because I'm good at this one thing. And even though that's a very important thing to be good at, that they know, it's like a doctor who like thinks they're better than therapy and they know more than therapy. I'm like, I had a freaking doctor one time say something like completely like trying to throw me under the bus. And I was like, okay, well, here's the gate belt. You have a good day. And I walked out of the room because he thought he could do my job. So I gave him full license to do my job. And he stuttered more than me. Let's put it that way. I sat outside the room for a second before I walked back in, and I was like, would you like my help? I am that, like I said, I am that bitch. I am that bitch. I will work with people as well as they respect me. But when you disrespect me, I will embarrass your ass. And he said something, and he wanted to see the patient walk, so I handed him a gate belt, and I said, have a nice day. And the patient knew what I was going to do. Like, the patient and I had been working together for like 2 weeks. The patient and I were like, I wouldn't say thick as thieves, but, you know, we, the patient and I, we had an understanding of what was going to happen. And yeah, I walked back in like 2 minutes later and I was like, would you like some help? But then there's some people that are humble, because that person was never had an attitude with me again. That person never interrupted my sessions again. Because I think this doctor always had a bad habit of coming in and talking to my patients when they were in the bathroom. And I don't know about y'all, but when you're taking a shit, you just want to be left the hell alone. I don't know if that's just me, but like, you want to do that in privacy. So when you already have one person there to make sure you're safe, and now you have a doctor trying to come in and have a full-blown conversation with you while you're sitting buck naked on a toilet, not the most appropriate thing. So I handed the doctor the gate belt since he thought he could do my job, and I walked the fuck out. Patient was in the bathroom, by the way. That story. So I knew that he was not going to be able to help the patient off the toilet and clean the patient up, which is one of the reasons that I thought it was fucking hilarious that I left the patient in the bathroom with the doctor. I was like, you want to talk to my patient when he's in an inappropriate position, you can do it without me. Just saying. Like I said, I advocate for my patients, and it's even if it's to teach a doctor a lesson of letting the patient have some privacy. You can come back in a few minutes when the patient is done in the bathroom and dressed. Just a FYI, if you're a doctor, whoever sees this, and you come in on a patient in an acute care setting and they're in the bathroom, come back later. What you have to say is not more important than their dignity and privacy. Just a thought. It's bad enough that they have to have somebody there to help them. They don't need you there too. Like I said, I am that bitch. That's me. Yeah. I'll advocate for my patients, but I won't hesitate to throw a doctor under the bus. Sorry, Dr. Joe, if you're watching this. I love you, but you seem like a good guy. False statement concerning material fact. The representer's knowledge that the representation is false, and an intention that the representation to induce another act on it, and consequent injury by the parties acting in reliance on the representation. Generally speaking, to satisfy the element of an injury, the claimant must establish that he or she has sustained pecuniary damage or injury by which he or she has been placed in a worse position than he or she would be absent the fraud. When you're claiming that she does not have CRPS, but you're billing for it because you know you're going to get a shit ton of money for it because it's a rare diagnosis. Just a thought. Yeah. Hey, like I said, I'll advocate for my patients, and my patient knew my patient knew what I was doing. So we had an understanding. He was like supervision, so he was safe. I wasn't going to leave him there if he was like mod assist or max assist. Like I wasn't that kind of person, but like, you think you can do my job? Here's a gate belt. Here you go. I have stories. I have so many stories. But these are reasons why I never want to work in a healthcare setting anymore, because I don't want these stories anymore. J. Hatch contends that the trial court erred in denying its motion for direct verdict. Mr. Kowalski presented no evidence that J. Hatch made a false statement of material fact in billing Mr. Kowalski's insurance carrier under a code for CRPS and presented no evidence of damages. We agree. There is no dispute that Maya was admitted to J. Hatch already having been diagnosed with CRPS by another physician. The dispute concerns J. Hatch's billing of the Kowalski's insurer, where, according to Mr. Kowalski, the hospital did not believe that Maya had CRPS and did not treat Maya for CRPS. They didn't. They treated her for Munchausen's by proxy, but they never actually diagnosed with Munchausen's by proxy. Interesting how that works. I want to get through this. Yeah, and I'm pretty damn positive. Like, I'm not a medical coder. I do not have like any good like I have some that are acquaintances, but nobody that I can like call up and just ask questions. You know, we're acquaintances, but we're not like, you know, talk on a daily basis friends. But CRPS is rare, and usually, like, for therapy, we'd get more for a neuro re-education than we would for a TheraCT. So anytime you did any sort of neuro re-education, you needed to bill for it because we got more money for it. You could consider anything TheraCT. TheraCT was kind of a catch-all. TheraCT was what you billed for when you didn't like have any specific like cognitive movements, like shoulder rehab for a stroke. You know, you're doing neuro re-education on how movement patterns for that arm. That's neuro re-ed. But TheraCT was like standing balance, stuff like that. Standing balance in prep for ADL completion with min assist from care, whatever. I'm, you know, getting too deep into the therapy world, but like, yeah, you can't treat for undiagnosed conditions, and you also can't bill for conditions that you claim she doesn't have, and you're not actively treating her for. You can't bill for something that you literally do not have in the medical record as a diagnosis. And I would seriously love to see the fucking medical records here and pick them apart with a fine-tuned comb. CMAs have to go through medical billing and coding. The laws are applicable to them when in education. Good to know. I have no knowledge. I have knowledge on my codes, And honestly, due to EMRs and just clicking Theract there, I have a hard time. Like even splinting, like there's different codes for splinting, but there's a code for actually making the splint, and then there's a code for fitting and doing work on the splint. And if you have to be accurate. Like you just have to be accurate. It is easy to fuck up. Like it is super easy, but we had a whole page on billing for splinting. Like I still have it on how to bill for a splint because you don't do it very often. So when you do it, you want to do it accurate. So we have education on how to bill properly, but we only get coding and stuff and the codes for what we do. There's no dispute that Maya was admitted to evidence of J. Hatch's billing was introduced as evidence of payments by the insurer. However, Mr. Kowalski presented no evidence that J. Hatch's bills included false statements. That Mr. Kowalski presented no evidence that J. Hatch billed for a diagnosis that Maya didn't have. This is where I would have to look back and actually watch the trial again. And I would love to see the billing, because if they did not have CRPS as an active diagnosis in her medical record, that's illegal. And this is where I think this judge and these judges are just, they might know the law, but they don't know medical billing. And it's like, Spawn Raiders, it worked. Spawn Raid. How are you guys? I am still going. I am ornery. I am bitchy. I am sassy. I am fucking fired up. But I want to finish this tonight, because if I don't, we're going to be pissed off for another day. And we have something else to get pissed off about tomorrow. Yay! Raiders of Spawn are always welcome here. Yes. Hey, Amos. So for you Raiders, we are going through the Maya Kowalski appeal decision. We did a part one. We did a part one earlier today, but I was unable to get through it as long as I wanted to, because I had to paint some walls, because someone decided that they wanted to do an art project on our walls today, and herself, even her face, she decided to paint her face blue. So just a normal day with Squid. Oh, you love me and you know it. Squid Pro Quo showed me I'm a god now. Yeah, I showed a few other people, and look where that got me. So, good. J. Hatch's bills included as many as 12 diagnosis codes. God, I fucking hate judges with bad grammar. Diagnostic codes. Thank you very much. And Mr. Kowalski was unable to testify what percentage of the insurer reimbursement was for CRPS versus other codes, including nutrition, endoscopy, and child neglect abandonment. That is where you needed an expert that was a medical billing expert and a medical coder, because they would be able to tell you, because it's not his job to know what percentage. But all you should have to prove is that not an active diagnosis in the medical record, billed as an active diagnosis. Two don't match, fraud. It shouldn't be such a hard concept to grasp. All right. Further, Mr. Kowalski presented no evidence that he suffered pecuniary injury for the alleged fraudulent billing. He presented no evidence that he was billed for treatment, whether as deductible, copay, or balance payment, that was associated with the CRPS diagnosis. Heidi, is it just me, or does that contradict itself? No evidence that he suffered pecuniary injury for the alleged fraudulent billing. He presented no evidence that he was billed for treatment, deductible treatment associated with the CRPS diagnosis. In fact, Mr. Kowalski concedes in this appeal that no damages in the form of increased copays, premiums, or deductible were proven at trial. And that's not the point. Whether you have an increased copay or not, where your copay changes. That's not how insurance works, Judge. It's not how insurance works. Once you meet a certain threshold for copay, then insurance covers everything. However, once you meet your deductible. However, just when you bill for something that you're not actively treating for, that is fraud. It's not a fucking hard concept. That is fraud. That is fraud. Like, that is you learn in college that when you are billing for something that you did not treat for, that you are committing a crime. You get taught that in college. Like, you get taught. In, I don't remember what class it was, because we had a little bit of insurance stuff in a lot of classes, but we were literally told, don't commit fraud. Literally, I remember one of my professors telling me that. Don't bill for anything you didn't do. And if you didn't do it, if you didn't write it down, it didn't happen. So if you bill for it and you didn't write it down, it didn't happen, and that's fraud. See how easy that is? It's not a hard concept. That's why when I say if someone doesn't write something down, it didn't happen. Because if you don't write something down, you might have done it. But if you didn't write it down, but you billed for it, it's fraud. Ugh. Moreover, in closing arguments, counsel for Mr. Kowalski suggested that the jurors award $1 in nominal damage for this claim unless they found evidence of an increase in insurance costs or copays. Post-verdict, Mr. Kowalski agreed to remit to the jury award to $2 because Mr. Kowalski requested damages only for deductible or copays incurred, and difficulty finding insurance in the future in the operative complaint, and such damages were not proven. Where the claimant is unable to prove that he or she was injured by the alleged misrepresentation, the trial court must grant a directed verdict on the claim. Trial court erred in denying motion for directed verdict. New trial. Complexities in this case are only more complicated by the existence of immunity. J. Hatch contends, as it did below, that the trial court's error in interpreting Section 39 proves not only the court's evidentiary rulings, but the trial itself, such that a new trial on all remaining counts is necessary. Footnote. That's a long-ass footnote. Long-ass footnote. Despite the concession that no pecuniary damages for fraudulent billing were proven at trial, counsel for the Kowalskis suggests that a trial court correctly denied the motion for directed verdict because the jury was entitled to consider Mr. Kowalski's loss of Mrs. Kowalski as billing fraud damages, and Mr. Kowalski's loss of Mrs. Kowalski would have reasonably supported a verdict of $5 million for billing fraud. No authority is cited for this argument, and we have found no basis in the law to support it. 21. We do not address whether those claims survive on remand under a correct application of Section 39, or otherwise we would exceed our function. We were to give an opinion on the merits of any of the claims for which a new trial is required. It is incumbent upon the parties to present the case anew for the trial. As discussed herein, we agree. Moreover, the totality of all errors and improprieties, including those not discussed herein, was pervasive enough to raise doubts as to the overall fairness of the trial court proceedings. And this right here is why judges will do things in the trial court that don't always go for one side or the other. So Munchausen's of the rares. CRPS is rarer than FMD or outdated conversion, but conversion can be misconstrued as Munchausen's. All of these can experience unethical medical gaslight, abuse, and neglect. Don't forget, there's a bunch of other things that can be added to that. But yes, you were very correct. Medical gaslighting is huge, and not in a good way. And it's even worse with kids because, Conclusion, the final judgment in favor of the Kowalskis is reversed. On remand, only the intentional infliction of emotional distress claim brought on behalf of Maya and the remaining false imprisonment, battery, and medical negligence claims may be retried. Oh, and I'm just not even... They just... Judge Smith, I concur in the majority opinion, but write separately to elaborate on discrete issue of whether J. Hatch was entitled to judgment as a matter of law on the threshold of outrageousness on Maya's claim for intentional infliction of emotional distress. Maya, age 10, presented to the hospital with a pain score of 10 out of 10. Miss Beatty, a licensed social worker employed by the hospital, was in charge of overseeing and making sure that J. Hatch followed the dependency court orders, including the monitoring of hospital visits, phone conversations with Maya's friends and family, including her mother. Miss Beatty spent considerable time with Maya overseeing her care, including her physical therapy and taking Maya to the hospital chapel. Fucking hate this judge. Including her therapy. She had more than just PT, you dumb cunt. Also, a social worker should not be overseeing therapy. That is not how that shit works. Thank you very much. And if a social worker ever says that they're overseeing any therapy, they're out of pocket. Straight out of pocket. Like, do not, no. No social worker is going to tell me how to do my fucking job. Sorry, I love my social workers, but damn, bitches. This judge clearly has a bias, and one, has a bias, and two, doesn't know what the fuck she's talking about when it comes to hospital structure. And this right here completely says it all. And taking Maya to the hospital chapel. Once again, that is not her job. Generally speaking, that is nursing staff's job. That is not social work's job. Just saying. There's lines that were crossed. I've never seen a social worker take any patient off the floor. That's not how that shit works. It's creepy. It's creepy. She testified that Maya was in her wheelchair 95% of the time that she saw. She all testified that she was furious, angry, and in pain. She told Miss Beatty she can't talk or trust anyone. Miss Beatty was privy to emails that highlighted the hospital's concerns that Maya was self-mutilating. Maya maintained throughout her stay in the hospital that she was in debilitating pain and testified that she was worse off at the time of her discharge than when she presented to the hospital. Maya also complained that her CRPS lesions returned while she was in the hospital and were causing pain. This is all to say that Maya was a patient in a vulnerable state, not only because she was a patient dealing with debilitating pain, but also because of her tender age at 10. Don't act like you fucking give a shit. Don't act like you fucking give a shit. From this evidence, a case was made by Maya that Miss Beatty took advantage of Maya's circumstances and her vulnerable state. She lied to Maya that Maya's mother was getting mental health treatment, telling Maya that she might have to go into medical foster care, and that Miss Beatty could be her mother while she was in foster care. Wholly inappropriate. Like I said, this bitch should be on a list. Catherine Beatty, if you see this, not like you ever will, but if you see this, your ass should be on a list. You should stay far, far away from children. She further lied to Maya and used things that Maya enjoyed to encourage Maya to do better at physical therapy. Physical therapy is not the only fucking therapy in the goddamn hospital, you dumb cunt. But instead of rewarding her, she would stomp and leave the room, saying that Maya did not do well enough. Maya also established at trial through her own testimony that the nurses spoke loud enough for Maya to overhear and that they believed her mom was causing her symptoms. Maya testified that the nurses berated her and accused her of faking her ailments. She stated that a bedside toilet was placed far from her bed so that she could not reach it without walking, which she could not do. Maya would call for help to go to the bathroom, but no one would come and take her, so she was forced to wet or soil herself in bed, or otherwise fall and injure herself. Maya testified that the statements and actions of the nurses and Miss Beatty were done to break her down and prove and or force her to admit that she was faking her symptoms. Wholly inappropriate on so many levels. Policy, patient safety, ethics, Ah, ah. Uh, just. Maya pleaded in her 8th amended complaint an intentional infliction of emotional distress claim, alleging these behaviors caused severe emotional distress and bodily harm. The complaint specifically referenced that Maya's vulnerability as a minor while she was still a patient at JHatch, alleging the defendant's offenses are aggravated by the fact that Maya was a minor during the time of this outrageous conduct. Yes, minor. She was 10. 10. Think about the emotional intelligence of a 10-year-old. Not to insult Maya by any means, but the emotional intelligence of a 10-year-old cannot handle all of this. The tort of emotional distress was first recognized by the Florida Supreme Court. In Metropolitan, the court set out the 4-part test as defined by Section 46. Deliberate or reckless, outrageous, the conduct caused emotional distress, and the stress was severe. This appeal concerned prong two as discussed in the initial brief and majority opinion, and so I only addressed this prong, outrageous conduct. Florida courts have long recognized severe emotional distress claims by vulnerable individuals under Section 46. Prior to Metropolitan, the 3rd District recognized that statements to a child of tender years can cause severe emotional distress under Section 46. In Corbin, the court reversed dismissal of a severe emotional distress claim brought under Section 46 of the reinstatement of the law of torts by a guardian on behalf of a 6-year-old child against the defendant. The defendant was alleged to have approached the child and said, "Do you know that your mother took a man away from his wife? Do you know that God is going to punish them? Do you know that a man is sleeping in your mother's room? God will punish them." The question posed by the court was whether that was said to the child was intended or reasonably calculated to cause the child severe emotional distress. The court answered that question in the affirmative, holding the alleged statements and the manner and the circumstances under which they were communicated to the child leave little room to doubt they were made with a purpose and intent to shame her and to shock the sensibilities of this child's tender years. Relating as they did to the child's mother, the content and import of the statement were such that it cannot be said as a matter of law that this caused alleged deliberately harmful act was not one calculated to cause severe emotional distress to a child of ordinary sensibilities. Yeah, I'm thinking that every member, like, how much you want to bet JHatch, JHatch's own employees don't take their fucking kids to JHatch. I had to soil myself in the chair bed and got creative to pee on the floor on a towel, no call button here, and no one would comply. When I would discuss the light over the bed was my signal. Ugh. Oh yeah, that absolutely harmful. Like, whether it's true or not, it's not the point. It's 6-year-old. Following Metropolitan, the 5th District recognized an emotional distress claim by a vulnerable patient against a healthcare provider. In McAlpin, the complaint alleged that the adult patient went to the hospital for an X-ray for her swallowing condition that caused speech difficulty and panic during attacks. Panic attacks? Upon entering the X-ray area, the patient was verbally assaulted by a hospital physician who claimed that because the patient owed the physician's friend money, the patient would not pay the hospital bill. The physician threatened to have the patient removed from the hospital. The complaint further alleged that actions of the physician were designed and did take advantage of the vulnerability of the patient, submitting as she was to diagnostic tests while in fear for her health and depending for comfort and solace upon the caring and supporting atmosphere to be generated by the hospital. I'm sorry, hospitals are not comforting, caring, or supporting atmospheres. Just saying. But since the president of JHatch didn't say it, then it's okay. Exactly. The trial court in McAlpin granted the physician's motion to dismiss with prejudice, finding the physician's demand for the patient to pay a friend's bill, while albeit not a favored method, was not sufficiently outrageous to rise to the level of an emotional distress claim. The 5th District disagreed, holding that the allegations of the complaint If proved, support the patient's argument that a jury, as the trier of fact, could find that the physician's conduct was reckless and utterly outrageous in a civilized community. We don't live in a fucking civilized community, so I don't understand. The law needs to take that shit out of because nobody in this fucking world is civilized anymore. No one knows how to act like a civilized fucking person. The physician acted in deliberate disregard for the high degree of probability that emotional distress would follow. In so holding, the district court reversed the dismissal of the emotional distress claim, recognizing the special relationship between a physician and a patient, and that the actions of the physician met the threshold test of extreme conduct, which would cause an average member of the community to exclaim outrageous. This court has indeed held the extreme and outrageous character of the conduct may arise from the actor's knowledge that some other is peculiarly susceptible to emotional distress by reason of some physical or mental condition or peculiarity. In Stedman, this court found instructive comment F to Section 46 of the Reinstatement of Torts because it explains how knowledge of a person's particular susceptibility to emotional distress is relevant to determining whether the conduct is sufficiently extreme and outrageous to constitute an intentional infliction of emotional distress. At the end of the day, remember, this goes back to Maya. She was 10. She was 10. So, like, when people are like, well, it wouldn't be outrageous to a normal adult. Yeah, to a normal adult with a fully developed brain. And who can make her own medical decisions. Remember, minors can't make their own medical decisions. Their parent or guardian has to do it for them. Affirming judgment for plaintiff following a bench trial where the physician cursed and screamed at patient who was known by the physician to be susceptible to emotional distress. Comment F reads, the extreme and outrageous character of the conduct may arise from the actor's knowledge that the other is particularly susceptible to emotional distress by reason of some physical or mental condition or peculiarity. The conduct may become heartless, flagrant, and outrageous when the actor proceeds in the face of such knowledge, where it would not be so if he did not know. It must be emphasized again, however, that major outrage is essential to the tort, and the mere fact the actor knows that the other will regard the conduct as insulting or will have his feelings hurt is not enough. The Stedman court viewed the facts of the case that collectively and not in isolation, holding that the actions of the insurance company delaying the authorization of the insured's double lung transplant was outrageous, where it was ordered by the judge of compensation claims to pay the claim, but delayed payment knowing that the insured would not outlive the delay and it would not have to pay. Wow, God. Yeah, and 10-year-old in pain without her mom. Yeah. Yeah. Her mom was her mom was a nurse too. So the fact that her mom was a nurse, her mom was probably far more knowledgeable and comforting than her father in this. Not to discount Jack at all, but like a little girl probably went to her mother because she could relate better to her mother, for one. And second, her mother was a nurse, so she's probably a little more comforting and made her feel better than her father. It happens a lot. We must acknowledge that the unequal position of the parties in a relationship where one asserts and has the power to affect the interests of the other may also supply the heightened degree of outrageousness required for a claim of emotional distress. Distress claims exist where one is susceptible to emotional distress or due to the unequal positions of the parties, and this was raised by the Kowalskis in the 8th amended complaint. Specifically, the complaint asserted that Maya, aged 10, was sheltered and placed in the care and the custody of J. Hatch, that J. Hatch was charged with looking out for the best interests of Maya while in their care, and that Maya was isolated from her family, friends, schoolmates, and priest. I believe the allegations pleaded in the 8th amended complaint and it as more fully developed at trial support Maya's theory of recovery for emotional distress under both comment F and I of section 46. Restatement of torts. What is odious and utterly intolerable in a civilized community? about the conduct here is that a licensed social worker in charge of the care of her patient should not lie and tell her patient, especially a patient of such a young age, that her mother, who has cared for her, is getting mental health treatment and will not be able to care for her in the near future. Instead, consoling the child that she will be fine in foster care, where that social worker can be her mother. Further berating by the nurses that Maya was faking her symptoms is equally odious and utterly intolerable in a civilized community, especially given Maya's physical condition and their knowing that Maya believed herself to be suffering from CRPS. Just as the patient in McAlpin went to the physician for an x-ray for her medical problems and instead received verbal abuse, Maya too went to the hospital for debilitating pain and treatment, only to be broken down, mentally abused, and berated by Miss Beatty and the hospital nurses who were in a position to facilitate her care and treatment. This case hits me too. You a little more personally than me from a caregiver's perspective, but you personally, but this just hits on so many different levels that it's hard to, this is why I wanted to get through it all today. Instead of having to go back to it and emotionally, like, I just want to give Maya and her family just a giant fucking hug. Like, I can't imagine what she's feeling right now. Based upon Maya's mental and physical condition, Miss Beatty and the nurses acted in deliberate disregard for the high degree of probability that emotional distress would follow. The common thread amongst the cases upholding the outrageousness prong is the shockingness of the statements, given the unique circumstances in which these statements were made. In my opinion, the trial judge will have to weigh whether or not some of the facts that fall within the Chapter 39 immunity would be relevant and admissible on retrial as they relate to Maya's emotional distress claims. When considering a claim for emotional distress, the facts that specify that specific case must be considered. Applying the facts that the specific case to reverse the dismissal of an ED claim holding in a situation where a person's loved one has died, it would be apparent to anyone that the person would be susceptible to emotional distress and therefore that the action providing false information concerning the loved one's cause of death meets the standard for an emotional distress claim. Williams versus City of Mineola, noting that there are times where behavior which in other circumstances might be merely insulting, frivolous, or careless becomes indecent, outrageous, and intolerable. Context is everything. Long story short. While I agree that some of the actions taken by Miss Beatty, the nurses, and others related to J. Hatch are entitled to immunity under Chapter 39, and that battery, false imprisonment, and medical malpractice claims cannot be used to meet the legal threshold for Maya's emotional distress claim, I also agree with the argument raised by Maya in her brief that Chapter 39 did not authorize or protect acts of intentional infliction of emotional distress, especially when committed by a healthcare provider whom vulnerable people look for care. And I believe that some of the information related to Maya's shelter and the dependency court's orders would be relevant and admissible to the extent the information is required to give the jury a full picture of the circumstances at the time. It's hard to imagine in a civilized community that accepts the actions of Miss Beatty. Bitch, you should be on a list. Yeah, they acted like crap, but immunity. Yeah. A licensed social worker and the nurses as good faith participation in the requirements of Chapter 39. See, this I agree with right here. It's hard to imagine a civilized community that accepts the actions of Miss Beatty, a licensed social worker, and the nurses as good faith. I don't. To be sure, J. Hatch makes no attempt to cast such a broad net to include these actions as privileged under Chapter 39, and in fact agreed at oral argument that Chapter 39 immunity was not absolute. However, even after stripping Maya's ED allegations of the offending claims and immunity-entitled evidence, there remains competent, substantial evidence that supporting the trial court's finding that Maya's emotional distress claim met the high bar of outrageousness. These healthcare providers were in charge of caring for and treating Maya. Instead, they exploited their positions with full knowledge that Maya, a 10-year-old, would not be able to endure such outrageous conduct and undoubtedly suffer severe emotional distress as a result. The case finding conduct outrageous are no different than the actions taken in Maya's case. In fact, Maya's case, given her vulnerable age, paired with her special relationship as a patient under the care of Miss Beatty and the nurses, is a more compelling one, which would cause an average member of the community to exclaim outrageous. For these reasons, I agree that Maya's emotional distress claim should be retried with the remainder of the counts. And here's that thing. Here's that last part by the other judge. It's so frustrating because, like, here, we've been at this for almost 3 hours. It is so frustrating that they're like, yeah, they acted shitty. But chapter 39. They acted shitty, so your mom died. So your mom self-deleted. Chapter 39. Here's that last part to me was written as like I know this sucks. Like, this needs to go to the Florida legislature. The Florida legislature really needs to read this. They need to see this. They need to see the appeal. They need to see the case, the appeal of this brief. They need to see that chapter 39 or that point, whatever it is in Florida, needs to be fucking revised because this shit cannot happen again. Honestly, I don't know what's going to happen from here. I don't know. I have no privileged information. And I'm not really sure that I want to. However, I hope that they get some sort of peace from this. I can't imagine growing up without my mom. Chronic pain sucks. And this case also brought to light how much our medical system does not understand chronic pain. And it just sucks on so many levels. Like, I'm disgusted by J Hatch. I'm disgusted by J Hatch from not only a patient living with chronic pain, but a healthcare provider. It's hard to imagine. I could never be an employee there. I would lose my ever-loving mind because I'd be like, this is wrong. I don't agree with this. This is wrong. I probably would not get along with the therapists because they obviously don't do very well. Then the nursing staff and therapy staff seem to have very poor communication. Poor Maya. Like, I don't want to pity her because she's a grown-ass woman now. She's 18. She's probably 19 by now. Like, I know that they just want to move on. Like everybody in these court cases, they just want to move on. And now that we're back at square one, instead of having yesterday be a day to celebrate that it was finally over, they're fucking back at square one. It's oh yeah, the lawyer, there was a problem. Well, there was an issue with the lawyers. More like sympathy. I'm the type where empathy requires me to put myself in someone else's shoes, and I can't. Sympathy allows me to give my best to someone and let people know that I care. But empathy requires me to do something that I can't do. Empathy requires you to feel what somebody else is feeling and put yourself in their shoes. And none of us can actually do that. So sympathy is a better word to describe what I like to what I think I'm feeling. But anyway, we are going to get out of here, and I am going to go to bed. So I appreciate everybody for being here. We are going to redirect over to the expert, hopefully, if I can find it. The expert is live right now doing pumpkin carving mayhem. I don't know exactly what pumpkin carving mayhem is, but we're about to find out. So I have that all set up. Y'all have a great day. Great stream when I did a redirect. Yes. Wait, you did a redirect? Wait. Don't you have to be monetized in order to redirect? Don't you have to be? Oh. Oh, all right. Y'all have a great. This spawn is monetized. Shh, don't tell anybody, but go send him super chats. All right. Y'all have a great night. Tell expert I sent you, and I will see you guys on the next one. We are talking Charlie Kirk tomorrow. Probably 5 o'clock, maybe 2 o'clock or 5 o'clock, one of the two. Anyway, bye guys.